The terms grantor and grantee will be found on almost all real estate documents. So what does it mean and how do you interpret that when looking at title records? This is Dave at titlesearch.com. On a real estate document such as a deed, the grantor is the party that's granting away or transferring away property rights. The grantee is the person receiving property rights. So when you buy a piece of property and there's a deed of that property that transfers from one party to another, the grantor is basically the seller. The grantee is basically the buyer. Now, at the same time that property is purchased, if there is a mortgage on the property and the mortgage is used to purchase that piece of land, then the roles will be reversed, because in that case, the owner or the buyer of the property is now the grantor, because they're transferring away property rights to that lender in exchange for getting the mortgage. The lender is now the grantee because they're receiving property rights. They're receiving the collateral of that piece of real estate to guarantee the loan. So at the same time in history, one person could be the grantor and simultaneously be the grantee on another document. It's not always going to be the same identifying label for one party. It just depends upon which way property rights are being transferred. Also, property rights don't have to be complete. A person can transfer away part of a property, maybe just an easement on a property, maybe just a lien against a property, without transferring the entire property. In fact, a mortgage is a type of a lien. It's what's called a voluntary lien. It's a lien that is done voluntarily in order to get funding for the purchase or even a home equity loan. If you have more questions about real estate records or real estate documents, you can reach us at our website at titlesearch.com.